When I was in Contracts 101 14 years ago, it was a Socratic method class, and the prof would call on a classmate and say, "So, what's the issue with this case?" And inevitably, they would respond and say, "Well, there was no consideration." And I had no idea what they were talking about. And because I had just come back from Japan, I had this image in my head of consideration being more about respect for people around you. And I somehow made it make sense in my head because all these contracts cases were from centuries ago in the UK. So I thought, oh yeah, of course, it must be some kind of gentlemanly respect kind of thing. So you can imagine how confused I was when we finally got to a class where the subject was a peppercorn could be sufficient consideration. And then I really had no idea what was going on. So turns out that consideration is just a fancy way of saying something that you get in exchange for something else. And that's at the core of contracts. And it's also relevant to determining contract defects in employment law. And so this is how it shows up. When you sign an employment contract that has a bunch of restrictive terms in there, you are getting employment in exchange for agreeing to all those terms, including a strict termination clause in many cases. So what happens then if when you get that initial contract, it only contains some of the stuff like your pay, benefits, vacation, you sign it, start the job, and then they say, oh, hey, by the way, all the restrictive stuff is in this policy here, take a look at it and sign it. Well, there's no consideration at that point because you've already started the job. So in that case, all that restrictive stuff that shows up later on, unless you get some kind of consideration for it, like another pay bump or a signing bonus, it just won't apply to you.